Welcome to AM Talk. It's a segment on our show where we discuss very topical issues in our country. We try to break the issues down, and we also share thoughts from MPs and other very important persons in our society. Well, today we're engaging two members of Parliament. Andrew Ejapamesa is a lawyer and an MP for 2nd D. And Roxanne Nelson Dafamapo is also a lawyer and MP for South Dai. Good morning to you, gentlemen. Ejapamesa, I saw you there.
Morning, Mamavi. How are you?
I'm very well, thank you. How are you?
I'm well. Yourself?
Very well. Thank you for asking.
Great.
Yeah.
Great.
Can I say hello to Mr. Roxanne Nelson Dafamapo? Mr. Dafamapo, if you can hear me. I guess not quite.
My friend, Mr. Ejapamesa, MP for 2nd D. Ejapa, I haven't seen your name. I want to see your name as a deputy minister. It has to happen.
That is the sole prerogative of His Excellency the President.
I'm praying for you, my brother.
This your mischief will not fly this morning.
Well, I want to ask you both if you've taken the COVID tests that the Speaker told us some members had taken. Did you take the test, Ejapamesa?
Yes, I did. Indeed, that was my second in 2 weeks. I'd taken a test immediately after the swearing-in ceremonies. Let me say good morning to our cherished viewers. It's important. And, of course, to my constituents in 2nd D who are taking time off this morning to watch us. And, so I've taken a test, I believe, on the 10th. Yeah. And then subsequently, when the Speaker indicated that parliamentarians were to do a test, I did so again on the scheduled date that my name was indicated to take. So I did indeed took the test, yes.
Would you mind sharing the test results?
Well, for the second one, I have not been informed of the outcome, which then presupposes that I was negative. But to be honest with you, I tested positive the first time. So I went through the necessary protocols and thankfully my symptoms were mild and I've duly recovered and back to work.
Okay, great. But the second test that was done through Parliament, you don't have the results?
No, I don't. Because I guess that the protocol with respect to the test that we do in Parliament, this is not the first time that we've done a test in Parliament, was that it is only those who tested positive who were contacted to then proceed to take the necessary steps relative to isolating and subsequently seeking treatment if need be. Yeah.
Okay. So this was about a week ago, you say?
Yes, about a week ago.
All right. Let me ask your colleague. Mr. Dafamapo, did you take the tests?
Hello, Mama B.
Yes, sir. I can hear you. Did you take the tests?
Yes. And let me add that routine medical testing is part of something we do in Parliament. Indeed, last year when the issue first broke in the country and became severe, all MPs were directed by then Speaker Michael Quay to also test. And I recall that some didn't do it, so it became an issue. So I think sometime in June or July, before we went on recess to go and handle the campaign, those members who didn't go through the test were actually compelled to go and test. You know, so it's something we do from time to time.
Okay.
And when new Parliament is also sworn in, we are taken to a comprehensive medical testing and review. So it happens to be the case that this time, when we went through that comprehensive medical testing, COVID became part of it.
Okay.
So I also went through the test. Indeed, if today is Thursday, so I did my test 2 weeks ago as part of the general medical testing of new members.
I know you wouldn't mind sharing your results with us, the test results.
To Parliament. I'm negative.
Okay.
Yeah.
So
But
isn't
we have
this
been
even
fortunate.
helpful? So that when we
Mama,
hear that there are other MPs who don't want to take the test, or some have taken the test, tested positive, and they still walk into the chamber.
No,
That's shameful, isn't it?
I think this is what is happening. Out of the 275 members of parliament, the testing is done for all the parliamentary service staff as well, security men, workers, anybody who works within parliament is also asked to go through the testing. So the numbers were really high. And some members who were not available at the time that they were allotted to test. So, for instance, on our side, I knew of about 8 members who were not available to test. Some too decided to do private testing and to submit the report to Parliament. So I have to place that on record. And then some too who tested positive also were asked to stay away to take care of themselves. Even though they are asymptomatic, they've been asked to go and do self-isolation and go through the protocol. So the medical doctors attached to the clinic of Parliament handled those things. But I think Speaker's position is that, the leadership, they have the list, so they know who are the positive ones and who are those who are yet to contract the disease. And so I can understand Speaker that if he knows Honorable Member A is positive on the list that he has, and he sees him in the house, he will be apprehensive. So it's a good call that if he tests positive, you just stay away, go through the protocol.
But do you know any of your colleagues who tested positive who are still visiting the house?
I know. I know.
Do you know any of your colleagues who also refused to take the tests?
I know it's not that they refused. I think they were just informed that from the list that they have, they are yet to do their testing, so they should go through. You can't say you refuse. It's not something you can refuse to do. It's for your own good. Perhaps for one reason or the other, they were not available to go through the testing. And like I said, others who decided to go to private medical centers to do the testing and submit the report. But the point I want to make is that every single person, it's a requirement that every single person goes through it, so you know your status. And the contrasting we live in a single continuum. You can test negative today, and tomorrow you test positive.
Absolutely.
So it's not as if because you test negative, you shouldn't take precautions so that you don't contract it. It's possible you can contract it tomorrow. So Speaker is only sounding a word of caution to everybody, including staff who serve us in the chamber.
But Mr. Speaker is also worried that people who have tested positive are still coming to Parliament. They are still coming into the chamber. Yesterday, listening to the statement that the First Deputy Speaker read, I mean, that's what it sort of suggests. There are people who have tested positive, who are MPs, who are still visiting the House.
Yes, Mama V, I spoke to that matter. What I said was that matters of medical issues are confidential matters. But like I said, leadership and speakership of the House, they will have the list. So, for instance, my brother Ijapa cannot know that I am positive or negative of COVID-19, and I don't know his status unless he shares that with me. But the speakership or leadership of Parliament, they will have that list.
Okay, just a final one, then I'll move to Ijapa. Are you in favor of a publication?
Publication of the list?
Of the list, yes.
No, I'm not in favor because these are medical matters and they are confidential matters. It's a matter of law.
But I thought you'd be more worried that someone sitting next to you has tested positive and is still showing up.
Yes, so like I'm saying, medical records are matters of confidentiality.
This is a pandemic. Okay, let me let you hold it for now. Let me get Ejapa Mensah into this conversation. Let me get his thoughts as well.
Medical records are strictly confidential.
Okay, so now we're speaking law. There's a pandemic staring us and we're talking law. Let me ask Japan Mesa, are you in favor of a publication of the list of those MPs who have tested positive?
Well, maybe, of course, I mean, you need to ask the same question of yourself before you extend it to the MP. So I guess that, and I agree with Rox. I mean, yes, we are in a pandemic. We all agree. People's medical records are confidential to them. They can elect to disclose it or otherwise. I don't think that Parliament...
But if you're not being responsible?
Well, that is why the Speaker has indicated that those who are not, then of course, clearly, he can use some other means to compel you to take the necessary steps as is required of you. But for him to just publish, and indeed, it is not everybody's list or name which will be published to the extent that that person is abiding by the clear rules that when you test positive, you self-isolate. And then, of course, when the 10 to 14 day lapses, at which point you obviously, per the science as we've been told, you cannot transmit, you go for a further test to confirm you're negative before you can resume regular duties. So I think that those who are aware that they've tested positive and are not abiding by the rules ought to take a cue from the Speaker's announcement yesterday and do the needful. It's in their own interest.
I'm just worried, when news like this goes out there, people would say, oh, look at our MPs. They are not even doing it. And you want to force us to do it. I mean, do MPs understand that people are watching and learning from what you do and you are in a leadership position?
Well, yeah, I agree. But I'm saying that relative to the disclosure of personal medical records, the Speaker will not have the power to do so unless he is compelled. There are very limited circumstances under which those records can be made public. And so to that extent, I can only implore my colleagues who are in that situation. And I know quite a few who tested positive, who did the needful, stayed away, and have duly recovered and are back to work.
Are we challenging the Speaker's authority to publish the list of names of those MPs who tested positive?
I'm not sure that any of our comments suggest challenging the Speaker's authority per se, but relative to disclosure of medical records, of course, that's why he sounded the warning, because I agree that this is not some disease that is personal to you, that is not transmissible. We are in a pandemic, and so the expectation is that everybody who has tested positive will do the needful by self-isolating. And so if you're a member of Parliament and you know that you've tested positive and you're not doing so, then I guess that that will include a Speaker with powers to disclose or name, that individual and ask that he does what is required of him.
Mr. Nafamako, let me allow you, the last word on this.
Yes, Mama, let me, and my brother is aware that it's not only MPs that patronize Parliament or the chamber. Anytime we are sitting, we have over 100 parliamentary staff, 7 members of Parliament, those that send documents around. Even journalists have access to our chamber, the way the chamber is arranged now, especially when we are using the tent, security men and all that. So the focus should not really be on MPs who are MPs alone. The parliamentary service staff that we come into contact with every day, even when we are out of session. So it's important that we, as an organ of state, we focus on protecting each and every member or staff that works within the presence of Parliament. That's my point. So I don't think that the attention should be on, or the responsibility or otherwise of this matter should be entirely placed on the heads of MPs. No. We may not be the only source of a contamination. There are other agents, like I've mentioned,
Yeah, but I don't think that's what's been suggested. I mean, we find it a bit disappointing that parliamentarians, some parliamentarians will either refuse to take the test or some have tested positive and they are not isolating and treating themselves.
Let me tell you how Parliament works every day when we during a session. When we arrive, there are staff that come to you. You have to, for instance, sign your name. They give you a pen to sign. We use only one pen. If you are not minded to bring your own pen, that can be a source of contamination. They come to you, they give you documents. But we take steps to observe protocols. We sanitize, we do all that. So I am saying that apart from MPs interacting among themselves, we also have serious interaction and interface with other parliamentary service staff. So caution should also be thrown to those.
All right.
That's my point.
Let's talk about another matter which also came out of Parliament in terms of Mr. Haruna Idrisu's comment, which sort of suggests that even though there was a list talking about the membership of the Council of State, Parliament has not been notified. Can you expand on that, Mr. Dapamakwa? What's really the concern?
Now, the concern of my leader is the effect that the constitutional provision that governs that matter is very clear. And it has to be in consultation with Parliament. And so, in his mind, the fact that the President, Tuomoto, nominated those persons and simply forwarded the list for the attention of Parliament, it's not meeting the requirements within that provision, which to the effect that we have to consult. And so, if it's about consultation, you don't do so unilaterally. Consultation implies a joint effort. My effort should be there, my input should be there, yours input as well. So I think it's a matter. If you recall, there are one or two case laws from the Supreme Court on this matter in consultation with what does it mean. So it's not a point that we can belabor, but I think it's simply drawing the President's attention that if he has to consult Parliament, he should do the consultation. That's all his point.
Hasn't it always been like this?
Yes, but that's what the Constitution says. If something has to be done in consultation with another, the person has to be consulted. There are lots of provisions that are to the effect that, for instance, nomination of persons, sometimes if you want to appoint judges or Supreme Court judges, for instance, the consultations you have to be done with the Judicial Council, for instance. Judicial Council's input will be there. And so if you ignore them and you make the appointment, it's a problem. There are, I recall, other provisions, particularly if you speak of nominating. I don't have it on top of my head, but other statutory agencies will have to be consulted. So if you don't consult the people and you do so unilaterally, it creates a problem.
Do you share his thoughts, Mr. Japamesa?
Well, I don't, because in the first place, the list that came out pursuant to Article 89 of the Constitution lists various categories or includes two categories of people. One that the President himself, per the Constitution, I believe in 89 2D, okay, that 11 other members appointed by the President. The list of the 11 was there. And then it is under 89 2A that describes some persons whom the President has to appoint in consultation.
Okay, so if you permit me, or would you mind reading if you have it?
Yeah, very well. Article 89.
I'm in the constituency. I'm in the village.
No, I actually also have it. But if Mr. Mesa, would you read it?
Very well.
It says the Council of State shall consist of A, and this is 89.2. The following persons appointed by the President in consultation with Parliament. One person who has previously held the office of Chief Justice. One person who has previously held the office of Chief of Defence Staff of the Armed Forces of Ghana. One person who has previously held the office of Inspector General of Police. B, the President of the, so this is 89 2B, the President of the National House of Chiefs. And C, one representative from each region that is going to go through an election. If you see the notice, it was clearly indicated that the election of the regional representatives is going to take place sometime in February. And then, of course, D, 11 other members appointed by the President. So I'm saying that the list that was issued, 11 names on that list to be appointed so motu by the President. It doesn't require any parliamentary consultation.
How do you arrive at that conclusion? Because you're still
says.
No, but that's
because if you look at 89.2,
yes,
which says the Council of State shall consist of A, the following persons appointed by the President in consultation with Parliament, and D falls under 2.
No, the A, the 2 has an A, I, and then B. So the provision relative to A only limits the parliamentary consultation to the Chief Justice, one person previously held the office of Chief of Defence Staff, and the person who's previously held the IGP role. That's it. With respect to B, President of the House of Chiefs, it does not require parliamentary consultation. Indeed, if you go further to D and C, one representative each from the region who are elected, are they going to be elected in consultation with Parliament as well?
Okay.
They obviously are not.
Okay,
and
so
D, the 11 other members appointed by the President is the sole prerogative of His Excellency the President. So it's in respect of only the 3 people, the former Chief Justice, the former Chief of Defence Staff, and the former IGP, that he does in consultation with the President, not with the prior approval of Parliament, not with the prior approval of Parliament where you go through the process of he submitting the names like he does with parliamentary ministerial nominations and even appointment of judges, and the Speaker refers to the appointments committee for them to, if you like, vet the nominees before they submit a report to plenary for plenary to debate and either approve or disapprove of the nominations. It says consultation, question of whether the President should consult all the 275 members of Parliament, only the Speaker, only the leadership of Parliament. It's not provided for in the Constitution. So you recall that when the Speaker himself was making his ruling, he said that, well, consultation would even take the nature of a phone call. And he proceeded to say that he has not received any said phone call from His Excellency the President. So my point is this, that it should not be suggested that the entirety of the list that was put out by Mr. Eugene Hain, the Communications Director, Acting Communications Director at the Presidency, ought to have been done with the parliamentary input that my colleagues on the other side seem to suggest.
Okay.
It's only in respect of the 3. And even that, these are people who served as Council of State members during the first term of His Excellency the President. There's been no changes. And so the question is whether, you know, well, I really don't know, but I don't think that this is any big deal that they should be making a big fuss about.
Okay, let me just cross over real quick. Mr. Dafamako, this seemed clear. The explanation that is given, and I'm looking at I'm looking at the words again, the numbers again, and it's quite clear, the explanation he gives.
The explanation is given is not clear. You asked him whether he agrees with me. He said no. But in his explanation, he agrees that there are a category of appointees that requires that Parliament is consulted.
Except that the list that is out does not include that category of persons.
It does. It does include Georgina Wood, former Chief Justice. It does include former IGP. It does include former Chief of Defense Staff, Major General Dankwa also. So the Honorable Harunai's point is very, very clear, and it speaks to the law. And it is Parliament, so I even, in all humility, I even disagree with Speaker suggesting that it could be a phone call. No, Parliament is a house of record. So if we are to be consulted, we work by way of resolution. So President communicates with the House. President will send a communication to the House that I intend to have a full complement of the Council of State. And by the constitutional provisions, I am mandated in law to consult you. So can you...
But Mama V,
hold on. Japa, let me finish.
No, Russell, just to help you. If you read the statement itself that was issued, yes, there is a clear exclusion to the effect that the appointment of those categories of persons are subject to the consultation with Parliament. And if you don't mind, just read it. It says, paragraph 2, please, please. The President, subject to consultation with Parliament. That's the wording of the statement. So putting out the names in the first place does not amount to breaching the consultation provision itself. Yeah,
but Mr. Mensah, isn't this a shift in the argument that you were making? Initially, it was just the 11 without the others. But I'm just also making reference.
No. I said that the impression being created out there is that the entirety of the list that has been put out, okay, is to the effect that the President was supposed to have consulted Parliament before he made these appointments. And I'm saying that no, it is only in respect of a category that the parliamentary consultation is required. So I was clear in distinguishing those categories and proceeded to say that I don't see why they ought to make a fuss about this three. Okay? But clearly, if you look at the statement, it says that it is subject to consultation with Parliament. And so the argument really is neither here nor there.
Okay, Mr. Tafamako, just end because you were in the middle of...
Yes, yes, but you've allowed him to steal my time.
No, I did not. I asked the question, so I brought him in.
The Honorable Haruna Idrisu is not speaking of the entire list. He's speaking in respect of those that require parliamentary consultation. That has not been done. And it's my brother Ijapa saying that President going ahead to put out the names of these three persons in a statement to the whole world. That Parliament should say that now in consulting Parliament after the fact, Parliament rejects the name. It will create problems. That is why you have to consult before you agree. The agreement must come as a result of consultation. So, by what he has done, he's imposing the names on us.
So, Mr. Tafamako, that's why I asked what's been the usual practice. What is precedent?
The usual practice is that some of these things are done quietly. Especially now, some of these issues are coming up because of the nature and the circumstances we find ourselves. I don't think Speaker Michael Kwe would have said that yes, the President didn't consult me, even if that were not the situation. The Speaker back is saying that I have not been consulted, and indeed Parliament has not been formally consulted. So there are lots of things in the Constitution that we gloss over because of prevailing circumstances. But now we are looking at everything critically. The law must be observed to the letter. And my brother Japan knows that consultation, when you say you should consult, you don't select your names and send them to me. That is not consultation. That is imposition. You are compelling me to approve of them. But we are more than one former Chief Justice.
Mr. Mensah, this is certainly a point that you should appreciate, and you could find yourself on the other side someday.
Look, Mama B, prior approval.
Yes, sir.
It's not the same as consultation. Let's get the distinction clear. What are we talking about?
Mr. Dapamako,
that the president can only make appointments with the prior approval of Parliament, as in the case of ministerial nominees. The names have been submitted to Parliament accordingly. Is that what is suggested in this provision?
We are not speaking of prior approval. This is consultation.
Absolutely. So why are you saying that you can elect to approve of it or not? You don't have the power to approve or otherwise.
So let me ask you the same question, Mr. Mensah. What's been the usual practice?
The usual practice, like he said, that this has never become an issue before. It's always done on the quiet. And so I fail to see really what the fuss is all about.
Otherwise, it usually doesn't come out because we usually would have a speaker. We usually would have a speaker who belongs to the other side, or who
their own intent going forward into this 8th Parliament is what is being played out. Otherwise, really.
But Mr. Mensah, if we're going according to what has been prescribed,
I take strong exception to that expression.
Which expression, please?
Expressing that our intent is to go into this 8th Parliament is what is playing out. It is not my fault. It is not the fault of the NDC caucus in Parliament. It's not the fault of the Speaker or the Speakership, which consists of both NDC and MPP persons, that the President failed to consult Parliament in nominating the 3 persons. So where there are clear provisions of the Constitution, which is the supreme law of this land, it shouldn't trivialize the issue.
I'm not trivializing anything, but I'm saying that the statement that was issued itself.
You are speaking to intent.
That's not.
So if constitutional provisions are the danger of being breached, we shouldn't speak. No. You and I.
Nobody has said that when constitutional provisions are being breached.
Like you said.
Not speak. But I'm saying to you
an issue, but it is an
if you
now.
read
So
the text,
what should be the
no breach
nature of the consultation?
That's the point.
That's what we should be able to agree on.
Well, I can imagine that we will have a lot of these things happening, but can we just respect the provisions in the Constitution and just...
If I have to consult you to do something, do I have to ignore you? No. I can't do that.
Mama B, the text of the statement that was issued from the presidency is clear. The president, subject to consultation with Parliament. What does that mean?
Yes, but subject to consultation of Parliament, you've already put the name
appointing these categories of people to fill that role. What does that mean?
Subject to consultation now?
Why did he say prior consultation? Did he say prior consultation or post consultation?
So it just consultation implies
the president has indicated that these are the people that I'm appointing in consultation with you. What really the fuss?
All right, gentlemen, let's move on and talk about the election petition. And I don't know how we're going to be progressing if every issue will be an issue in Parliament. Then it will be very difficult in the future. But let's talk about the election.
My point exactly.
The election petition. Let's talk about the election petition.
My point exactly.
Well, we're watching you. We're watching you.
When your president dispense the Constitution, we will point it out to him. When your president dispense the Constitution, we will let him know.
No, he's not my president. He's the president of the Republic of Ghana.
Well, when the president dispense the Constitution, we will let him know.
Okay, listen, I think that these are all gaps that we're identifying because obviously, and it's a fact, if we had a speaker appointed by the party in government, these things would not come out. I think we should all agree on that, Mr. Mensah.
Speakers are not appointed by any party.
Oh no! I think it's the expression.
Speakers are nominated. They are nominated by the parties, and the parties.
Absolutely. I'm just saying so for the benefit of some of our viewers who may not understand.
Thank you.
Speakers are elected by members of Parliament.
Yes, sir.
Or by consensus or through a vote. And so...
The last one was not by consensus.
Was elected by consensus.
All right, gentlemen, let's talk about the
election. Were you elected in second year by consensus?
No, through a vote. And duly declared with exact figures obtained in the election. In the case of Right Honorable Speaker, that was not what happened.
I'm quoting the Speaker himself. He was elected. Okay, let's talk about the election petition hearing.
No, not the Speaker alone. The records of Parliament shows. The clerk says so. The Hansard will bear me out.
Are we going to be disagreeing on everything?
By how many votes?
Okay.
2 votes. That's a dog bite. 2 votes.
Let's now turn attention to the election petition hearing. You two are lawyers, so you can help us with some understanding. You've been following the procedures in Parliament. And yesterday there was a motion that was filed, dismissed. We thought we were going to see the EC's witness in the box, but that didn't happen because there was a continuation of the hearing only in chambers, and we didn't know what had happened there. Is there anything, maybe I should pick up from there. Mr. Mesa, is there anything from that in-camera hearing that you can share with us? What happened?
No, I'm not in a position to, of course.
Okay, but here's my thinking. Mr. Chikata may have said something to convince the panel. And I arrived at this because I'm thinking, or I was thinking then, it looked like they were going to continue with the proceedings, but after the in-camera, they just came back and agenda sitting.
Yes, and 2 things could potentially inform that decision, that they agreed that, well, they were going to agenda sitting and continue hearing by asking them to close their case, because obviously have not filed any formal witness statement by the time that pleadings closed, or that the court had made some concessions with the agreement of the counsel for the respondents, and had indicated that agenda matter till Friday for a new witness to be called. I frankly don't know.
Look, did they say a new witness will be called on Friday?
Well, they said they had a witness that because of ill health. Of course, that was disclosed in court. Mr. Chikata said something to that effect, that they were intended on calling another witness, but that because of some ill health, which they could not disclose in open court, they were asking that the matter be heard in camera, and the court obliged and went in camera. And when they came back, the agenda matter. So we can only speculate. But I'm saying that there can only be 2 outcomes on Friday. One, that the court agreed for the NDC to call another, Mr. Mahama, the petitioner, to call another witness, or that the matter will continue as is expected to, per the rules, if you ask me, because it is clear from CI 99 that all witness statements that you or the witness statements of all the witnesses that you intend to call ought to have been filed before the case management process commenced and hearing started, because the element of surprise clearly is prohibited by our rules, and as much as possible, the rules of court, and as much as possible, anything that the witness is intended on saying, particularly with respect to the new rules, because in the past, where we didn't have the witness statement, of course, the witness will come and provide his evidence without you knowing what was in his head. But now we have the witness statement, which everybody ought to comply with. But I guess that we'll await Friday. Friday is only tomorrow. And we'll see what it is that the court will say. But from our own perspective, this entire petition is a complete waste of everybody's time. It won't go anywhere. The evidence, pleadings, and the evidence that has been alluded so far before the court, that every observer, is taking notice of, clearly points to a petition that is misconceived, that has no basis whatsoever in law and in fact. And my expectation is that it's not going to stand. If you look at
the issues that has been set, If the petition had no basis, you don't think the panel would have dismissed it a long time ago?
Not at all, because this is a constitutional matter. And the practice of the courts, and by the courts I mean the Supreme Court, is to, regardless of the legal objections that have been raised, bear in mind that the respondents have raised a preliminary legal objection. The court proceeds to hear the matter in its entirety and provide its ruling, including a ruling on the preliminary legal objection at the time of delivering the judgment. So let nobody be deceived that by reason of the fact that the court has not dealt with the preliminary objection, that then suggests that they are in agreement that the petition has some basis. They just want to listen to both sides.
So why would the court waste its time and listen to both sides and go through all this
that's
long-winding...
the practice of the Supreme Court, that in constitutional matters, and this is not the first time, there are plethora of authorities that confirm the Supreme Court's decision to the effect that when a matter borders on some aspect of the Constitution, then we will hear all parties and then provide a comprehensive ruling. Bear in mind that the decision of the Supreme Court, binds all lower courts as well. And so there may be some questions of law and fact that may come up that would provide some authoritative basis for future adjudication of disputes in this country. So the courts, by practice, is minded not to dispose of matters at the preliminary stage, regardless of the objections that are raised, but takes it together comprehensively in their judgment. And that's exactly what the court indicated at the pre-trial, the case management stage. And of course, you did not hear the respondents oppose, because I'm sure that they themselves had apprised themselves of the practice of the court and knew, even though my expectation was that the Supreme Court, to the extent that they can depart from its practice, masters of their own rules, would have dealt with this matter as expeditiously as possible. Because look, to be candid, Mamavi, all the talk regarding issues with Dr. Kwesa White's evidence, regarding Mr. Asibin Kete's evidence, at the cracks of NDC's petition before the court, is that the Electoral Commissioner, in making the declaration, and they suggest that the declaration is what she uttered, not what the facts of the figures are. She used a certain figure, 13,434,574, which, according to them, was the total valid vote figure that the EC chairperson declared. And that if you look at the individual votes that were obtained by all the contestants, which is not in dispute, and you use the 13,434 as a denominator in calculating what percentage each candidate obtained, nobody got 50%. That's it. That's the case before the court. But the fact is that when you aggregate the individual votes of all the contestants, you get 13,161,111. That is the fact. And so what the NDC petition or Mr. Mohammed's petition is suggesting to all of us is that, Mamavi, you and I and Roxanne Dofia-Mako have gone into an election. 100 people voted for the three of us. Roxanne got 60. You got 50. You got 30 and I got 10. Now, 200 or 150 people actually took part in the election. Okay? Out of the 150 who took part in the election, 50 votes were destroyed. Spot. Only 100 was valid. You know you got 60. Roxanne knows he got 30. I know I got 10. Now, the referee, in this case, the Electoral Commissioner, in declaring the vote, says that the total valid votes cast is 150. When you and I know that the total votes cast, in fact, all the contestants know that the total votes cast is indeed and in fact 100. And I go to court the next day and say that, well,
you're justifying the correction or the mistake, right?
There was no correction of any mistake.
Oh, okay.
So the next day, the lecture commissioner comes, hold on, and says that, look, yesterday when I was announcing the result, I indicated the total valid votes was 150. Is it factual? Per your record, the record that you have. Is it? I'm asking you a question. Is it factual? And so if she comes and says, when all of us know that the total votes that is as a result of the aggregation of the votes of the three of us amounts to 100. But she says 150. And she comes the next day and says that, look, yesterday I said 150, but in fact, it's 100. You say because she said 100, she's changed the result. Has it changed the result?
Mr. Dafamako, is it
I'm asking you a question, Mama V, please, it's important.
Are you asking me a question?
Has the lecture commissioner, per this scenario that I've painted, changed the results?
Are you expecting an answer from me?
No, hold on. And I go to court and tell the Supreme Court that at the time of the declaration, the electoral commissioner mentioned 150 as the valid vote cast. When I know, as a matter of fact, that the total valid vote cast is 100.
Okay, thank you, Mr. Mensah. Thank you, Mr. Mensah.
Wait, please.
You are giving all the time to a Japa. He's repeating the same thing.
150 as basis for calculating the percentage vote of each candidate.
You've made your points.
Nobody won the election.
You've made your points. We appreciate that. Let me just, throw it to Mr. Dafamako. Mr. Dafamako, I'm asking.
It's the case of the NDC and the petition before the court.
Is it as simple as he's put it?
It's as simple as that. And I'm shocked that Ejapa is going round saying the same thing for over 10 minutes. What is the issue? It is part of the law, or it's a requirement of law that where nobody crosses 50% plus one, there has to be a rerun between the two persons that obtain the highest vote. And that's the law. So for him to suggest that we are in court because of that, as if it doesn't matter, it's neither here nor there. Now he's talking about figures. Is he aware that the Electoral Commission, in their answer to the Supreme Court, in response to His Excellency John Mahama's petition, they have quoted a different figure, different from what they released on the 9th, what they corrected on the 10th of December, and what they actually put up. So which of the figures do we believe from the Electoral Commission? And he says that this is not material, this is not an issue to be dealt with. They can be tickling themselves. And I'm very happy that he says that there are plethora of court cases, Supreme Court decisions, that says that when a case before them is about a constitutional matter, they will go into the merits and come out with a ruling or a judgment. But they are all over the place saying that they have filed a preliminary legal objection. And what is the government of that preliminary legal objection? It is to the effect that the petition does not disclose any reasonable cause of action. And so, in their legal mind, the court should make a preliminary determination and dismiss the matter. But it's on air saying today that there are lots of Supreme Court decisions that says that cannot be done. So I'm happy that he has put that matter. It's settled. Mama V, what are we talking about? You listen to our witnesses. You listen to our PW1. You listen to our PW2. What happened in court yesterday is something that happens all the time, where matters has to do with medical issues. They are strictly confidential, like I said earlier on in the other submission. So they are not matters that you say in open court.
Yeah, but nobody's raising issues with that.
So the judge or the judges will normally go into chamber and hear you. His point is that because of some peculiar medical conditions, you recall that in our pre-trial checklist, we indicated that we'll call 5 witnesses
But you filed only 2 witness statements.
Exactly. And so he's making the point that even the third person, the third witness that we intended to call, because of some peculiar medical condition, we couldn't even approach the person to gather the witness statement from the person. So depending on how the discussions went in camera, the court agreed and adjourned the matter. And so I will leave it at that. Whatever happens on Friday, we'll discuss that one going forward. So they should stop saying, and I heard him say that it's a complete waste of time. We are in court, cross-examinations have been done. We expect the respondents, and when there will be no re-examination of our witnesses, we expect the respondents to also open their case. And he says that it's a sheer waste of time. They can be tickling themselves and be smiling or laughing. But the court will come to a determination. When that is done, Mama, you and I and himself will be back to discuss the merit or the demerit of the judgment that the court will enter in this matter. And those will be my preliminary view.
Wow. That's all time will allow us on this matter. I
really?
was just... Mr. Mesa, I give you a lot of time.
It's interesting that
I give you a lot of time. What do you want to say again on this matter?
My summary of the cracks of their case before the court. Because he agrees with me that that's what the basis of asking the declaration to be declared of the election results, okay, CI 135, to be declared null and void, is the computation based on the denominator. That's it. The denominator.
According to the denominator. That all the 3 or 4 denominators that have been put out so far in official communication.
The 13434 574 that you use as basis for calculation, which was premised on what the EC chairperson said.
But Mr. Mesa,
are you aware the EC is quoting a different figure in the answer before the court?
Which different figure? Look, Mama B, look.
The answer before the court.
Okay, yesterday I had the proceedings, and I posted something on Facebook that the total vote cast figure of 13434 574. They're saying that the EC in their answer quoted 13433 573. Mama B, do the math. It's 1001, the difference.
But there's still some difference. So you agree that there's still some difference?
I don't have a problem, but I'm saying that.
No. Mr. Mesa, do you agree that there's some difference?
I'm saying that if the allegation is right, then there's a difference. Okay. But then the question of materiality arises.
Okay. So right. There's a difference. Why are we saying that? Why are we saying that it's a complete waste of everybody's time?
Inconsequential, because that is not what is used in computing the percentages for the candidates at the election.
The electoral commission is confused. The returning officer is a confused person.
Cross-examination.
She doesn't have
when
any
you
figure.
Add all the aggregate figures of the individual contestants in the election, you do not get the denominator that they are asking the court to use as basis for calculating the percentages.
Gentlemen, tomorrow is just around the corner. Do you, by the way, just before we go, do you foresee an extension in the time, for hearing this case? Because yesterday was, I think, day 4 in the trial. We've got 6 days for that. Tomorrow is Friday. Do you foresee an extension, Mr. Mesa?
No, I don't.
Mr. Dafamakpo?
That is a case that is dead on arrival, Mama B.
Mr. Mesa, thank you for answering my question. Mr. Dafamakpo, do you see an extension of time?
It's a possibility. This is the first time CI 99 is being tested. And so, depending on the circumstances of this matter, the court in its wisdom may extend the hearing date by a week or 2, depending on the constraints they have. So I cannot say definitively that they will not extend it when there's a need for it.
Have only 1 day
yes, sir.
They may not.
Okay.
Of the respondents.
Thank you very much.
Are not cast in concrete.
1 day to cross-examine the EC,
especially when it's about procedure.
Okay. Thank you.
And he knows. There's something we call enlargement of time. He knows.
Thank you, Mr. Dafamakpo. Thank you, Ejapa Mesa.
Cross-examine the witnesses of the respondents. Only 2 days. You want an extension of 2 weeks. You see, Mama B, when we say
Mr. Mesa, I've ended.
The import of this petition is to engage or dominate the media space for as long as they can.
Thank you, gentlemen, for your time. Thank you for the conversation. It's been interesting. I like the perspectives that you both bring onto the discussion, so I'm grateful. Enjoy the rest of the day. So that's our guest on AM Talk, Andrew Ejapa-Mensah is Member of Parliament for 2nd D, and Roxanne Nelson Dafamapo is Member of Parliament for South Dai. Up next, we're talking 2020 road accident leading into 2021. There was a gory one yesterday. Benjamin Akapo is handling that conversation with the police MTTD and the National Road Safety Authority. That's coming up next. Stay with us.